Hello, 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 beautiful people. As always, welcome back. 42 USC 1983. So you want to sue people, right? The first thing you need to know before you sue people is whoever has authority over you becomes the author of your life. Most people attempt to sue people because they want to be the author of their lives. When you write something on a piece of paper and you want it to be so, you're basically structuring your life one way or another. You're slowly taking the steps to write and dictate your life, to take control of your life. And one of those ways is suing people. That's good. But most are unaware that a lot has to first be done before they file any paper. A lot has to be done preliminary to file any suit. The preliminary things that has to be done is the research. The research and the things that will be used as a preponderance of evidence. In this situation, a civil action. If you intend to bring a criminal case, then it will be evidence that's beyond reasonable doubt. Before you file or deal with any situation, research should be your primary priority as to everything that you intend to talk about, as to why they've done something wrong and why you're right. When people just go filing papers without preliminary research, they've effectively perceived and made their rights some type of method rather than the result itself. They're working backwards, and that is usually so because most don't know why they're taking the action that they're taking. They either hear it or briefly read it somewhere by reference of someone else or by them stumbling upon it, and they just go along with it without researching details. This thing called 42 USC, which we've gone over in the past when it comes to things related to child support. On the patron page, we went over the fact that in this video titled Court 101, Civil Conspiracy Under Color of Law, Elements and Standards. Within this video that was posted on Patreon, we went over the fact that this thing called 42 USC, what it says on its face is not what it really is. And this is what is meant by that. When you begin to read the language of this thing called a civil action under color of law, you begin to realize that there's a lot that you have to fetter to it. And you too will run over the fact that this arose out of 14th Amendment, but even then, the rest of the Charter of how it's enforced lets you know you have to fetter it to the Bill of Rights, which is the first 10th Amendment. Anything beyond the first 10th Amendment is basically to favor the representatives of the United States, whereas the first 10th Amendment is the opposite. It's to favor you. Preliminary information of the tool that you're using is the important part. Rights and suing people is very much like working in a workshop filled with a lot of powerful tools. If you go in there without the proper equipment, without the proper gear to protect you, if you go in there without knowing what certain tools do and the varying degrees of how it's used, you're stepping into that workshop in a manner that's going to cause that workshop to be your graveyard. You don't want to do that. So here's a bit of an assistance and further details of what 42 USC and its subsequent sections, what it really means. On the Patreon page, we went over the elements and standards of what makes up a civil conspiracy claim under a color of law. This term, color of law, a lot of people will know it as, okay, they're doing something fake and bad. That's what it means, right? But how do you prove that? And what does the language within 42 USC really shows in details to show how you can prove it? And what are the elements of conspiracy? Because you have to remember, this thing called 42 USC is about conspiracy, but do you know conspiracy itself has standard and elements? And that standard of element in and of itself of conspiracy is embedded into this thing called the civil action or civil rights of 42 USC 1983 et al. What are the elements of an act performed under the color of law? Many people will tell you, well, it's just anything unconstitutional. That's good. But what are the varying details of how they're going to come at you and say what you're saying is wrong? Of how they're going to say you just saying that we're acting unconstitutional is insufficient. This video entertains that. But for those in the general public in YouTube, there's also something else very important for everyone to know, regardless of whether you're a Patreon member or not. And that is the applicability. Just like evidence, there's authenticity, applicability, there's the scope, there's admissibility, and there are exceptions. Let's talk about the applicability of 42 USC 1983 and the subsequent sections. In the matter of 42 USC 1983, suing people under quote civil claims. The core of it, of how and why it works, is entertained within the case law called Monell versus Department of Social Service of the City of New York. This specific res judicata is just cases decided relating to similar parties in the past. Their decisis is just basically legal principles. In other words, case laws like this are res judicata that uses stare decisis, which are legal principles, which could also include maxims. So res judicata is like Monell versus Department of Social Service of the City of New York, goes into the core of the intent of 42 USC. See, this 42 USC has a public law equivalent. Public law equivalent, as we went over in the past, is the original body of text and intent passed by the Congress. Subsequent United States codes is them compiling it for the purpose of research, for the purpose of commerce. But within the public law equivalence of any USC code, there will always be a section where Congress expresses to you what the intent is. When most people use any given right under any circumstance, they don't know what the intent of Congress is relating to whatever it is that they're making reference to. The intent of Congress is the core, it's a substantive aspect of that public law. When you start to use certain things and you don't align yourself with the intent of Congress, these people on a quote judicial level will not tell you that what you need to do is align yourself with the intent of Congress. They're just going to do is throw your case out. You've done everything right, but you fail to align yourself with the intent of Congress of that thing that you bring in as a claim. Therefore, they throw your case out. The intent of Congress is the applicability. The intent of Congress is what any given public law, prior to or after it's been statutized, is meant to apply to. In this case called Monell versus Department of Social Service of the City of New York, explains the applicability of the intent of Congress. And this thing called 42 USC 1983 and its subsequent sections were created. This is extremely crucial. When people say sue them, they never tell you the applicability of what they're telling you to sue them. When people say 42 USC 1983, they never tell you what the applicability is. It is extremely important for you to know the applicability. Albeit 42 USC would just be one of the counts within the claim that you're bringing. Let me say that again. 42 USC code. This civil action for deprivation of rights and the conspiracy thereof will be part of the counts, or one of the counts, of the claims you're going to bring in. You know that in civil actions, you can actually bring a claim on the tort without necessarily citing any type of public law, so long as you meet the elements and standard. Did you know that? Then you can fetter the damages based on equity. Equity has its damages at law, has its type of damages. Although usually you will find at law dealing more so with damages being monetary relief. Damages with an S. Damage is the issue at hand of what's been done against you. Damages with an S is the monetary compensation. But in equity, there are certain reliefs monetarily. But when you bring tort, even if you don't fetter it to this right here, you can still seek relief that way. But nonetheless, one of your counts will be civil action for deprivation of rights. So let's look at the applicability. Just so you know, as we've shown in other videos, there's an equivalence on a state level with every specific requirement of the federal aspect of 42 USC. Although on a state level is usually more so specific to race, ethnicity, gender, sex, and religion. Whereas on a federal level, it's really more so about the violation of the right in and of itself, rather than the violation of the rights being fettered to your identity through race, gender, sex, religion, or ethnicity. So that's the difference between federal civil rights actions and the state civil rights action. Federal civil rights action has its origin in something called the Ku Klux Klan Act that was later codified into this thing you're looking at as 42 USC 1983. So what is the applicability of this 42 USC 1983? It is very simple. In summary, the applicability of it is that it can only be used to sue entities. In other words, you cannot hold anyone personally liable with a 42 USC 1983. The concept of persons being dual in nature, in some cases more than dual, but generally speaking, the two branches are artificial persons, aka juristic person, aka creatures of law, aka ex legis, or a natural man and woman, the one who has blood flowing through their veins, the one who brings to life any given thing that's written on a piece of paper. This thing called 42 USC only applies to the first rather than the latter, first being the artificial entity. This thing called 42 USC 1983 was specifically created based on intent of Congress. This thing called 42 USC civil action for the deprivation of rights under color of law and the conspiracy thereof is applicable to corporate entities. Corporate entities are those acting in corporate capacity that, quote unquote, John Doe doing business as CEO. That's not you suing them personally. The moment you evoke their capacity as a CEO, as a director, as an employee, which a president is also an employee of an entity. If you invoke any capacity under a corporation, even if you're saying that it's a man or woman, if you're suing them as a capacity of a CEO, that is still a corporate person. That's a placeholder of a corporate capacity. So when you use this, it would apply to them as CEOs, and it would apply to the entities itself that is hiring them as a CEO, but not personally. This is what they call a Monell claim, which came out of this res judicata. What this res judicata did was it reaffirmed that corporations are persons to their own capacity, separate from their owners. Now, this does not annul the personal liability if the operation of the corporate persons does something outside of their scope of duty or capacity in the process of damaging you. But said personal claims cannot nonetheless be made under 42 U.S.C. claims. There must be claims under the Bill of Rights. That's one exception. Second exception is the concept of Respondeat superior cannot be invoked for 42 U.S.C., aka Monell claims. Again, the applicability is it's only applicable to corporate entities. The exception is that if you bring in 42 U.S.C. that is applicable to corporate entities, you cannot use it to hold people liable personally. And Respondeat superior doctrine is inapplicable. So if you're saying you're suing some employee, and because of you're suing the employee, you're bringing a CEO into the case. Did you know when you sue under 42 U.S.C., you cannot sue the CEO for the act of the employee? But then there are exceptions to that also, which is based on the regularly conducted business activity or the culture within that working environment. You would always hear me in other videos speak about the culture of an environment, of the conditioning of the employees. That's being mentioned for a very specific reason, because if you want to hold them liable, which by the way you should be doing it on both ends, on a corporate level and personally. If you want to hold them on a corporate level and you want the Respondeat superior doctrine to apply and waive the exception of a Monell claim, aka a 42 U.S.C., aka civil rights claim, then you will have to show that there's a pattern of culture that caused that damage to you. If you can show that there's a pattern of culture, then that links the interests of the higher up to the activities of the one who are just following orders. This is where people also try to do things like private contracts before, during, or after the damage was done towards you. If you can send them a notice and show that a private contract exists ahead of time with the intent of preventing the act that occurred from occurring, then you can invoke Respondeat superior doctrine. No private contract exists due to lack of time or stringent circumstance, then it can be invoked by claiming deliberate indifference standard and the malicious standard where they knew better and thus performed outside of their scope of duty. See now what I mean when I say elements and standard? Because the confines of this thing called civil conspiracy under the color of law is meant to lock you in if you don't know the principles of how elements and standards work. The only way you can remove yourself from that bind and lock that's been put into the algorithm of how this thing called 42 U.S.C., aka civil rights under the color of law, is the provision, aka Monell claim. The way the algorithm of it works, if you don't know certain elements or standard of other things, you will not be able to get out of the lock and traps that's been placed in. So let's look at its applicability and the principles behind why civil rights under color of law, aka a Monell claim, cannot be used to sue people personally. So let's look at the analysis of this case itself. First, the court undertook a fresh review of the legislative history of the Civil Rights Act of 1871, now codified as 42 U.S.C. 1983. When it says the court undertook fresh review of the legislative history, it's referring to the intent of Congress, aka the legislature. Legislative is the act of creating law. the judicial department, aka the court, reviewed, then they put into consideration the lawmaking history, aka the intent of Congress, behind this thing called Civil Rights Act of 1871, now codified as 42 U.S.C. 1983. Remember, we're looking at Monell versus Department of Social Service of City of New York. It goes on to say that Monroe versus Pope relied upon the holding that municipal entities were not, quote, persons subject to 1983. Pay attention here. The court examined the vote in Section 1 of subsection 1983, the Sherman Amendment and its vote, the text of the vote on the first Congress report, and the text of the vote on the second conference report. Remember, there are 16 stages to how laws are made. And within these stages, certain reports have to be made within the members of Congress. And these reports constitute the process of them looking at the intent of how they're going to structure a certain legislature, aka a certain body of law, who it's going to apply to, what the exceptions are, the scope of it, how to put it to use. That's basically what this first two sentences mentioned. The court found that Congress did intend, remember we start off by speaking about the intent of Congress. If you say you have some right and you're not aligning yourself with the intent of Congress, you are doing yourself a great disservice. If you say you have a right and you have yet to do some preliminary research on how the intent of Congress was to align with what you say you have as a right, you are waiting to be turned into an angry monster who is going to complain and say they're all fraud. That's all you're doing. Know what you are doing before you step into it. Do you know the elements of conspiracy? Do you know the elements of what it means to behave under color of law? All these words jumbled up together. Do you know the elements to it? And then relate those elements and standard to the intent of Congress of the language or the section of any legislature that you bring it forth as the procedural due process, the operation of law to enforce your rights so that you can seek relief, redress through the grievance called a bill or a complaint. These things are what people are aloof of. They step into these world with just expectation that if I file a piece of paper, that's it. No, that is not it. So pay attention. The court found that Congress did intend for municipal entities to be included amongst those, quote, persons to whom subsection 1983 applies. Subsection 1983 being civil action for the provision of rights, which says every, quote, person, every person who under color of any statute, ordinance, regulation, customs, meaning it's telling you can use or make reference to one of these as a foundation as to why your rights were violated. These custom is the culture that's not necessarily written on a piece of paper, is a policy within a private organization called a police department of something, which are all closed corporation, or called a city or village of something, or called a corporation or the LLC of whatever it is. They're not written down formally, yet they are enforced. Listen to these keywords, because these keywords are where your rights sit. When those attorneys create barrier to you and say, oh, you haven't stated a claim, you're just talking a bunch of crap. He doesn't know what he's talking about. She's clueless. Just throw the case out. If you don't comprehend the language of what you're saying your rights are, you wouldn't know that customs are one of the things that affect how damage is performed against the everyday man. Customs does not exclude and does in fact include the things that they just casually do. Everyone just knows it in that working environment, beyond what's written in the employee handbook, beyond what's written beyond the policies. They just do it because they're all well acclimated to one another and they're trained to do so. And it includes that arbitrary custom within the language of what people say constitutes the procedural due process, the operation of law, to which they're enforcing a substantive right that's reaffirmed within the Bill of Rights, which is required to invoke a civil action for the provision of rights under a color of law and the conspiracy of the same. So now when it comes to persons, this case law Monell lets you know that despite what other case laws have said, the intent of Congress, after looking at some of the 16 steps of how laws are created, when this thing was created, this term person, before it starts to go into what the activities are, this premise of person includes municipal entities. Every person who, under color of any statute, ordinance, regulation, customs, meaning sometimes you just don't have that thing affirmed on a piece of paper that this is the reason why they do it, but you just know deep down based on how they just casually came in, they didn't even question anything, they called someone else and they just, they went along with their buddies and just shitted on you, right? That's considered a custom. What is a custom? It's a noun, a usage or practice, meaning it's something they just do. Common, they do it regularly. To many, meaning it's not just you, but it's a repeated action that's second nature. Or to a particular place, meaning it can also just be in your circumstance. They just decided to deal with you arbitrarily. But it's something that they have well practiced. It's something that they have well used in the past. A usage or practice common to many or particular place or class, or habitual with an individual. When any municipal employees approach you or speak to you over the phone, it's like a sales pitch that they go through. They ask you a series of questions. They look at how you react. They look at your temperament. If you're a little bit soft with it, if you're friendly with it, if it's a child in a big body wearing some uniform who feels a need that they can get away with something because they've seen that you're soft with something, they would enforce habit. Humans are creatures of habits and pleasures. It's part of human nature. That's what humans are. We are habitual creatures. And the intent of Congress put that foundational principles into consideration when they constructed the language of this thing called civil action for deprivation of rights under color of law. Remember, we're under the definition of what custom is. Custom is one of the things that you can point to say someone has deprived your right. And custom includes the habit of someone. Repeated practice, long established practice, considered as unwritten law. It's not written down word for word that this is what they're supposed to do or not do, but they do it nonetheless commonly. One, I'm letting you know, one of the affirmative defense that they're going to bring against you is, well, they can't show that we did anything wrong. We followed our policies. So they don't have any civil rights claim. But guess what? Part of that same civil action lets you know that you can point to customs. If you don't know that customs simply means habits that are not necessarily written down, and you're not entertaining that principle also based on the totality of your particular circumstance, you can easily waive your right. It's not the responsibility of the opposing attorney to help you prove your point. Neither is it the acting judges. And if they even throw you hints, if you've not done your preliminary research, all you're going to do is get mad and see the worst in whatever the acting judge puts in the minute or the order. So pay attention. Every person who, under color of any statute, ordinance, regulation, customs, or usage of any state or territory in the District of Columbia, subject or causes to be subject to any citizens of the United States or other persons within the jurisdiction thereof through the provision of any rights, privilege, or immunities secured by the Constitution and laws. Laws meaning anything harmonious with the federal Constitution. So when you see this thing called Constitution and it's embedded into some type of federal public law, whether it's statutized or not, the presumption that it's speaking about federal Constitution. And when it says laws, it's referring to subsequent public laws on the federal level or subsequent public laws, session laws, slip laws on the state level. And it also refers to the state constitution, so long as it's harmonious with the federal Constitution. Shall be liable to the party injured in an action at law, suit, and equity. Meaning you can bring equitable claims under this principle of civil action for the provision of right. Meaning you can bring equitable claims under this principle of civil action for the provision of right. Meaning you can bring equitable claims under this principle of civil action for the provision of right or other proper proceeding for redress, except that in any action brought against a judicial officer for an act or an omission taken in such officer's judicial capacity, meaning anyone that's presumed to have judicial immunity, this does not apply to. Because if they have judicial immunity, they are not acting under color of law. Therefore, you've not been deprived of any right. Therefore, they acted constitutionally. Injunctive relief shall not be granted unless a declaratory decree was violated or declaratory relief was unavailable. This person, which is the premise of who this is applicable, is what Monell focuses on. The court found that Congress did intend for municipal entities to be included among those, quote, persons, as we've read right here, to whom subsection 1983 applies, and that Congress at this time would not have thought the statute unconstitutional as applied to local governments. Local governments are municipal entities, and municipal entities are persons. Local governments are persons. Therefore, 42 U.S.C. 1983, civil action, civil rights under color of law, so the provision under color of law is applicable to local governments as a person to their own. Because when the Congress created this, they did in fact intended for this to apply to municipal entities, aka local government, because they are persons. The court wrote that Monroe Court misinterpreted the meaning of 1983, which is this initial case that says that persons do not include municipality. The acting judge probably got paid off. And in this case, Monell versus Department of Social Services, City of New York, clarifies the fact that this case called Monroe versus Pope was wrong, because 1983 applies to municipal entities, aka local governments. But this is not really a cause to jump for joy, because within the fact that they're delineating corporate entities, aka local governments, aka municipal entities, as persons to which an action against the provision of right is applicable to, that also simultaneously limit the extent to which that civil rights that is being deprived, that is being brought under 42 U.S.C. can be used to just that type of person called local governments and municipal entities. The court wrote that Monroe Court misrepresented the meaning of 1983, and that were 1983 unconstitutional as applied to municipal entities, it would also be unconstitutional as applied to municipal officers. In other words, it's telling you anyone acting under the capacity of a municipality is also effectively classified as that same corporate person. When you sue someone under the capacity of an employee, no matter what the derivative of that capacity is called, whether they're janitor, whether the patrolman or the patrolwoman, whether they're a representative of some state police, whether they're the clerk, whether they are the security guard hired by the city because they need more foot soldiers, they are an employee. And the moment you sue the employee, it is as though you're suing the person called the entity itself. It is up to you to delineate the capacity to which you're suing them. When you say John Doe doing business as CEO of so-and-so county, so-and-so city, know that just because you say doing business as a CEO, that itself is not you suing them personally, but in fact it is you suing them in the capacity of an employee, aka a corporate person. If you want to sue them personally, write their personal name, John Doe, comma, personally. Simple as that. And another section, the body, where it shows jurisdiction, venue, and parties, where it says parties, you will make it very clear that John Doe is being sued in his personal capacity. And since personal capacity is joined when it comes to court, aka in personam, aka personal capacity, through service of process, you would also show right after that their last known place of abode was so and so. You show where they personally live, because that's where service of process will be done to join them personally. Here is another thing a lot of people don't know when you sue people. The way you join parties, personally or corporately, is where you serve them at. We'll say that and we'll leave it there. The court wrote that the court noted that 1871 Congress clearly intended Section 1983 to apply to such officers, and agreed that they, remember when they say officers, they're referring to the corporate capacity now. So they're not straying far away from anything beyond corporate capacity. When they refer to officers or municipal officers, they're also simultaneously and vicariously referring to the entity itself, because the entity is what gave right to any given position. And if anyone is playing any given position, it is for the purpose of that entity itself, rather than personally. So when they use persons here to apply to local government, it includes their officers. In other words, any employee, regardless of what their title was under that company, any employee is merged with a corporation the moment you sue them as the CEO, the moment you sue them as a patrolman, the moment you sue them as the sheriff, the moment you sue them as the clerk, the moment you sue them as the recorder, the moment you sue them as one thing or the other. So long as what you're suing them as has a title under the corporate capacity, then it is as though you're suing the corporate entity in and of itself. Again, it is up to you to delineate that you are suing them personally. The way you sue someone personally is to know how personal jurisdiction is merged within the case. And it's in Rule 4 Federal Rules of Civil Procedure. It tells you. It's through service of process. Either that or through the maxim that says that an error in the name is cured through an error of appearance. And if someone is saying, well, you spelled my name wrong, or this name is all cap, or you didn't join me, the moment that you serve that paper called pleading, you submit it to the court's jurisdiction. Those are two of about 5 ways personal jurisdiction to be joined. But moving on. The court noted that 1871 Congress clearly intended 1983 to apply to such officers and agreed that they could be subject to liability under 1983, and that the act was also clearly intended to provide a remedy against all forms of official, aka corporate, violations of constitutional right. In other words, this thing called 42 USC is only applicable to remedy if you do not intend to sue someone personally. Now, within the same suit, you can sue them both personally and in their corporate capacity of a CEO or whatever role they play. You can do that. But whenever you place that count 1, count 2, count 3, and you put civil action for the provision of right based on some part of the Constitution, and you show the elements and standard involved in that, know that the limits of liability is going to be corporate. If you want to sue them personally, you have to show something else outside of civil action for the provision of right. This is the reason why about 2 or 3 videos on YouTube were done letting you know, if you want to sue someone personally liable, this is not where you're going. So don't be delusional with yourself thinking you're going to hold someone personally liable with 42 USC. But if you do want to sue them in a corporate capacity, you still have to know the elements and standards of whatever it is that you're claiming beyond the verbiage in this thing right here. On Patreon, we have went over that, or at least we went over some of that. On here, on YouTube, we're letting you know that the applicability of this is based on corporate capacity only. So do not be delusional about that. Second, in overruling Monroe versus Patton, the court considered that Monroe departed from prior practice insofar as it completely immunized municipal entities from liability under 1983. In other words, you're saying that the intent of 1983, aka 42 U.S.C. 1983, aka Monell claim, aka civil right of action under color of law, the intent of it was to apply to municipal employees. But this previous case law, called Monroe versus Pope, did the opposite. Therefore, it was overruled. Reasoning that there was no principal distinction between school board and other municipal entities, the court found that its many cases that held school board liable were inconsistent with Monroe and were a further indication that Monroe should be overruled. The court ruled that immunizing school boards against liability under 1983 would be contrary to instances where Congress refused to immunize school boards for federal jurisdiction under 1983. The municipalities could not have arranged their affairs so as to be able to violate constitutional rights indefinitely, and therefore could not have a reliance interest in absolute immunity. In other words, or in so many words, municipal entities are strictly liable under 1983. And pay attention to something very subtle that they slipped in here. They mentioned something about arranging their affairs, the way any municipal entity arranges their affairs through their private policies. And one of the elements to a civil right action of the provision of right under color of law is they will tell you, okay, point to one of the policies that violated your rights or that caused them to violate your right. Why? Because one of the elements of it, mentioned on the face of it, speaks about regulation, aka policies of any given entity. Third, the court, in analyzing the legislative history, aka the intent of Congress, found that Congress did not intend for a municipality to be held liable under 1983 solely because it employed a tortfeasor, and that therefore a local government could not be held liable under Respondeat superior. Let's read that again slowly, and then we'll explain what this means. Third, the court, in analyzing the legislative history, found that Congress did not intend for a municipality to be held liable under 1983 solely, aka just because and employed a tortfeasor. What they are telling you here is, whenever someone acts in a manner that is against the Constitution, that violates your substantive right, it cannot be the fault of the employer. Because common sense says that a body politic, aka a corporation, aka a municipal entity, aka the local government, does not always know that it is hiring someone with the propensity to treat others in a torturous manner, aka employing a tortfeasor, as highlighted right here. Therefore, they don't know the possibility of the act that whoever it is that they're hiring might violate the law. Therefore, the entity itself shouldn't be held liable for personal acts of their employee. That's the reasoning behind why 42 U.S.C. 1983 is only applicable to corporate entities, and why this thing called Respondeat superior does not apply, and why you cannot use it to hold people personally liable. Because in the process of hiring people, they don't know what their propensity is to be tortfeasors. Therefore, the due diligence is now on the one suing, aka you, to investigate the personal information of the tortfeasors and join them personally, because personal jurisdiction is gained when service is made personally to join parties in specific capacities. Listen to that again until you really get it. This is also the points of view in employee files. Do you know all these cops have employee files that you can actually view? How many people speaking about suing people know that you can view their employee files and show that as intent, aka mens rea, and show that as part of their repetitive? You can do that by public record or by their employee files. These are preliminary research that you must do before filing any suit. This would also raise the question that shouldn't the corporate actors do their research first on the type of people that they hire? Because if they are hiring people that have propensity of damaging others, then shouldn't it be their fault for hiring such a man or woman? That's the question you should be asking yourself. If they're trying to say you can only bring it to provision of right under code of law and only have it applicable to municipal entities, because, well, they don't know whether they're hiring a tortfeasor or not. Your mind should be countering this by saying, well, shouldn't you, the ones employing them under the corporate capacity, shouldn't you do your research on the behavioral pattern and propensity of who's being hired in the first instance before hiring them? And think about it, if they hire someone with a master's degree, bachelor's, or heck, someone who barely even has a high school degree, don't they do a background check? Isn't that part of the normal mode of operation of at-will hire or contractual hires? You should be asking yourself that question. Because this is the loophole where Respondeat Carter's concluded that the corporate activities are to solely focus on a corporate interest, and thus look at the corporate record of the man only. And when they do background check, it is for the sole purpose of benefiting their corporate activities. Just like an employee of a corporation will go to their boss and complain. If your complaint is not benefiting the commercial interests of the one you're complaining to, they will turn that around and use it against you. So when they do background checks on all these employees that they're hiring that's going out there acting gung-ho off the wall, they're only looking at their background check and their previous employee files from a lens or from a perspective that, okay, is this man or woman going to make his money? Are they? Good. That's all we care about. Now go out there and write as much ticket and make as much arrest. However you do it, whether you do it unconstitutional, we don't care. Just make money for us. Most of these people don't know their rights anyway. And if they say they don't know their rights, it's just the what and the verbiage. They don't know the how and why, the intricacies of how to hold us liable monetarily or personally. This is the reason why they can get away with these things. It is always the fault and the liability of the one who says they have the right. Because if you say you have a right, that's power. And with power comes responsibility. And your brain has to be working. Your mind has to be working. The brain is not just that thing in between your skulls. The brain is the whole nervous system, and the sympathetic and the parasympathetic system in your whole body. The stuff that makes your heart beat without you thinking about it, that's your brain. The stuff that makes you pick up information without you thinking about it, that is your brain. That's connected to everything. Don't let it go dormant. Don't let it turn into a dust and wither away. Think. Use it. In short, these people do not consider whether the ones they're hiring will damage the general public that they will begin to interface with. That's the reason why the court within Monell, which they were using interchangeably to refer to 42 U.S.C. 1983 as, quote, a Monell claim. That is the reason why they viewed it in perspective that Congress did not intend for a municipality to be held liable under a Monell claim, aka 42 U.S.C. 1983, aka civil action for the provision of right. They viewed it from perspective that the Congress did not intend for it to apply only because the entity employed a tortfeasor. Therefore, local government could not be held liable under Respondeat superior. Because, well, how would they know who they're hiring? So now you ask, well, shouldn't you know who you're hiring? Because you should be considering that there will be interfacing with the public and damage the public if their record shows that they have a propensity to be a tortfeasor. Well, the corporate interest says we don't care. We only care to make money. If you watch the video about closed corporation and lifting the corporate veil that was posted on Patreon, you see what this is meant. There's a standard for that. Courts view things in light of and the benefit of corporate activities. This is what this is basically telling you. These are the subtleties that are in between the lines with the rest of the card we're reading. So now, if you are the everyday man and you are ignorant about how laws are enforced beyond being upset, beyond what's written in black and white, then they would never lose money. And if they never lose money, there would never be an incentive on a business level for them to go, okay, look, we see you have a history of doing this in your personal background, and we think it might blend into your impulse during the job, and someone might sue us and we will lose money, so sorry, we can't hire you. If you don't know what your rights are, if you don't establish things properly, they wouldn't have that state of mind. Rather, they will have the opposite and go, yeah, we see what you do, but these people can't sue us, so welcome, just go make us some more money. We see you're an aggressive one. That's good. We want aggressive ones so we can make more money. They are comfortable in hiring the mischiefs of society. They're comfortable in hiring little children in big body. They're comfortable in hiring those who are losers, who've been bullied once upon a time and are looking for some justification, using a position as a cloud for their low self-esteem, for the anger that they have for someone who probably did something horrible to them as a child, and now they just want to take it out on the world and make the world suffer, even though that constantly makes them empty forever. But so long as they can get that instant gratification and get rewarded for it through the customs of the entity, which is the loophole to this thing right here, letting you know when you bring this civil action for deprivation of rights and you sue them in a corporate capacity, they'll tell you, well, show us a policy, because that's the limits of what we've done, of what we can do. But you can speak about customs, which are things that are not necessarily written on a piece of paper, that is a common practice. Which, when you really think about it, any type of tortfeasors or damages, that's where it comes down to. That's what it always comes down to. It's never, whenever someone damages you, it's not according to what the law says. It's always because of some personal prerogative, some personal feelings, some personal perspective that they feel, you know what, I'm going to impose this on you to prove a point. And once they do that once, the second time, third time, constantly, and they realize most people are dumb and don't know their rights, it becomes a custom. It becomes a culture within that working environment. It is up to you to make an example by digging into their pockets so that they make a smarter decision when hiring people, so that they make smarter decision when hiring hypnotists and martial artists and people who can train them in firearms and spending hundreds of thousands and millions in equipments, so they can think twice about that while they're training their employees, that someone like you is out there to dig into their pockets. Remember, we're not even going into how to sue them personally just yet. We're not going to speak about that on YouTube. That's for sure. But when it comes to one of the two ends of the spectrum of how you can sue them, we're going to give you the basic caveat here on its applicability. Because most people don't even know how to enforce this at all. They just don't. And it's quite unfortunate. But one of the reasons why that's unfortunate is because they don't even know the applicability of it and the subtle substance of these things. Think of anyone working for any department of any municipalities to which this is applicable to. Some of those people are mischiefs of society, who are justifying their intent and will to make you, the everyday man, pay for their pain by putting on costumes, by holding titles, by holding positions. Question yourself and ask yourself, do you want to be the victim to some shithead who doesn't even know anything? Most of these people working for municipalities are not intelligent at all. Their emotional intelligence, their spiritual intelligence, their logical intelligence, it is extremely low. But guess what? The customs in the working environment allows them to exercise their filth by using their position as a cloud to justify tort. And it will keep going on until you figure out how law and its operation functions, until you figure out the intricacies of things. This is one of them we're going over in this video. It's not your fault that those before you haven't taught you these things, because it's part of the plan. Because even though older generations don't have it figured out, the older generation are confused. The older generation are also the ones acting as tortfeasors. The older generations are the ones who are in legislature creating laws that are screwing people over. The younger people are just tagging along, being a victim to it. And they get frustrated and they themselves turn into tortfeasors because that's all they've been conditioned to know and respond to. Be better than that. Do better. Take that umbrella that they're trying to use to cloud themselves and to shield themselves, take it and crush it. But you can only do that if you're competent. You can only do that if you know the applicability and the scope of what applies and the intricacies involved in what applies. If it's too difficult for you to skip trace, if it's too difficult for you to hire a private investigator, believe it or not, you don't even have to. In 21st century, you don't have to hire a private investigator to get people's private information, especially if they work for a municipality. That is a guarantee. These people working for municipalities are the easiest to find their information. But if you don't even know how to do that to join them personally, and you sue them in their corporate capacities, you can still make it hurt. Because this thing called 42 USC has a cap per count of the damages, the monetary relief. The earlier one has a cap of 3K. The most recent version of this has 5K as a cap for each count, for each damages, for each occurrence. But there are ways you can raise that, not only through punitive damages, but through other types of damages. Competence is your key. So if for whatever reason their policies can be shown to be unconstitutional, or any of the statutes, in some situations they'll say, oh, you violated this. They will sue you for it through malicious prosecution, but you actually never violated that. AKA they're acting colorably. How do you show that the way that they acted malicious towards you falls under this, you can show that through the customer usage. A lot of people fall into this trap of trying to say, well, they were not well trained. See, what you should be making a claim under Monell is not that they were not well trained. What you should be saying is the presumption exists that they were in fact well trained to do that based on custom. And at that point, all you have to show is any document that shows the hierarchy of who is at a certain job. We'll say that and we'll leave it there. If you're suing some type of dispatcher company who circumvented the need for probable cause finding, which is not their job, so they did a probable cause finding through the phone call, which has no indicia of reliability, and there's entropy of information, and the dispatcher effectively acted as a witness and started probing for probable cause. Oh yeah, did they do this? Did they do that? Outside of what whoever called is telling them. All you have to show is that, you know what, they were in fact well trained to do that. Get any document that shows the hierarchy that a director within that dispatcher company is the one that directly supervises the act of the dispatcher, and you have a Monell claim. Things are not difficult. People are the ones that make it hard. Because at that point, it is not up to them to say that, no, they're not well trained according to our directors. There's no way they will come and say that their employees are not well trained according to their director, because now they've effectively buried themselves. Now that leaves you an open door to say, oh, so you did not train your employee properly. Think ahead. But how can you think ahead if you don't know these little small details? The court reasoned that since there was no clear statement in legislative history justifying the excluding municipality as quote persons under 1983, such entities could be sued directly under 1983 for policies or customs that violate the U.S. Constitution. We went over the fact that customs are not necessarily written down, but are repeatedly enforced. Listen to this. The court, however, required that 1983 claims against a municipal entity be based on the implementation or execution of a policy statement, ordinance, regulation, or decision officially adopted, meaning it's formally written down on pen and paper as the standard, adopted and promulgated by the parties, officers. Additionally, the court held that municipal entities, quote, may be sued for constitutional deprivation visited pursuant to governmental, quote, customs, even though such a custom has not received formal approval, aka officially written down, through the body's official decision-making channels, aka their directors, their CEO, their mayor, their board, aka the board of trustees. Local government may not, however, be sued under Section 1983 for injury solely by its employees or agents. In other words, a municipality cannot be held liable under 1983 on a Respondeat superior theory. It keeps using this qualifying term solely. And there are other things you have to better if you want to attach superior into the circumstance. Another element to suing someone based on Respondeat superior is based on first-hand knowledge and experience. Then whoever it is that you're saying is the superior has to have first-hand knowledge and experience of what's going on or what happened to you. How would they know the first-hand knowledge and experience of what happened to you? You have to show it through the customs. You have to show the links of direction of the fact that whoever it is that's a superior is well aware of the act that's performed by that inferior employee against you, because it's what they've been instructed to do. Why? Because they've been well trained to do so. A lot of people make the mistake saying that, well, they were not well trained, and it's your job as the employer or the CEO. You didn't train them well. That's why they're doing this to people. Why would you say they didn't train them well? Why would you give them a way out? People think backwards. For those who are quick to jump to the conclusion that, oh, well, why are you saying that? You shouldn't say that they were not well trained. Because, well, they should be funded properly, or they should not be funded properly because they're not being trained. You are making the wrong contention that's been killed. in 2021, last year. The summary of it is the court opened that the moving force was not a failure to train, but the officer's failure to keep the training, meaning they would never admit that they did not train their employees properly. If you're stuck in the whole, they did not train them well, they should train them properly, who are you to dictate how they're going to train their employees? What's important is the outcome of how it affected you. Therefore, hold them liable under the presumption that they were well trained based on customs. Then the case JKJ versus City of San Diego. Officers stopped a Cadillac with an expired registration and soon learned the two men in the front seat had prior drug conviction. They also learned that Aaliyah Mariah Jenkins, a backseat passenger, was subject to an arrest warrant. The officers searched the car and found two wallets, one of which was full of cash and drug package and material. They did not find any drug. As the officers questioned Jenkins, she spoke coherently and showed no sign of distress. They arrested Jenkins, handcuffed her, and put her in a cruiser, where she vomited. The officers called for paramedics and asked Jenkins if she was detoxing. Jenkins responded, "No, I'm pregnant." The officers canceled the call for paramedic. Then they say, screw your child, screw that life that you're nurturing in your body. You know, basic tactic of war. Why should we save the young child if we're attacking the parents, right? So they canceled the paramedic despite the fact that they've already called it. But wait, if you're on drugs that we're regulating and creating, oh yeah, we definitely want to keep you alive so you can keep being our customers, whether by way of us arresting you and making money through commission and through creating municipal bonds, or by way of you being a consumer of the drugs which we regulate, which keeps us in business. So you're not on drugs, you're not detoxing from drugs, oh, never mind, you don't need a medical emergency. To hell with you and that child. That's basically what just took place here. As the officers drove Jenkins to a station for fingerprinting and processing, she groaned and screamed for help. When she got to the station, Jenkins was hyperventilating. After fingerprinting Jenkins at the police station, officers returned her to the cruiser. Several minutes later, they found her unconscious, called for paramedics, and begun CPR. Jenkins fell into a coma and died 9 days later. A surviving minor child sued. The court opened that moving force was not a failure to train, but the officers' failure to heed their training. The court opened that the moving force was not a failure to train, but the officers' failure to heed their training. In other words, you can use this concept against them. Don't be stuck on wanting to show that, oh, well, I have the right to say that they have to be trained this way. That's none of your business. Your business is to say, this is what you're going on about. Cool. You're going to be held liable for it. Just as if you say that you're an SBC or more, you'll be called for it. You will have to show and prove. The trial court dismissed the lawsuit because it did not state a valid claim against the defendant. The appellate court affirmed the dismissal. The court granted the qualified immunity to individual officers. The core allegation against the officers was that they failed to recognize and adequately respond to Jenkins' serious medical need. Meaning, when someone is suing, you should not sue under the presumption that they're there to assist you. Another video on this is done based on public trust doctrine as to whether they have any responsibility to protect you or not, outside of corporate intent of making money. The court found the right was not clearly established in the specific context of the case. You have to know the specificity of your case. Just because someone throws some snake oil at you and tells you you can sue them for this, you can sue them for that, does not mean your situation and case is applicable based on the context and totality of circumstance of what took place. You have to know the standard test and the elements specific to your circumstance. Thus, the officers were entitled to qualified immunity. It is your liability to prove and show your right that you say you have. Your right cannot be tethered to whether they were trained or not. Your right must be tethered to the fact that they did in fact violated you outside of what the law says they're up to. Not whether they're trained properly or not. Whether they're trained properly or not is not stipulated by the Constitution. It's stipulated by their policy, which you're not a party to. The plaintiff also brought Monell claim, aka 43 U.S.C. 1983, against the city. Remember, we just went over that, the city being the entity. According to the appellate court, JKJ had to plead facts alleging that 1. Jenkins was deprived of a constitutional right. These are the elements. 2. The municipality had a policy. 3. The policy amounted to deliberate indifference to Jenkins' constitutional right. And 4. The policy was the moving force behind the constitutional violation. The court held the plaintiff's complaint did not plausibly allege any city policy or customs, quote, was the moving force behind the alleged constitutional violation Jenkins allegedly suffered. To the contrary, the court opened that the moving force was not failure to train, but the officer's failure to heed their training. In other words, they're saying you shouldn't have brought up the issue of custom. And the fact that they did not heed the training is a custom, rather than you trying to attack some policy that's inapplicable to you. Even the 42 U.S.C. 1983 tells you that it has to be tethered to the Bill of Rights. And then you have to know the standard element of test of whatever tort you bring in. And then attach that to the fact that they were well trained and they violated the standard test and element and the Constitution by virtue of that. This is an example of the challenge faced in suing a government agency under a Monell claim, at the same, aka 42 U.S.C. 1983. At the same time, the case reminds officers to call for medical attention whenever it is reasonably necessary to do so. What reasonable means is up for grabs, based on how competent you are, based on whether you know the standard, test, and element. See, whether you use 42 U.S.C., 18 U.S.C., whatever it is you want to label as the procedure or due process, you will still have to know the standard, element, and test to the intricacies involved. You can never run away from that. There are layers to it. If you're saying you're bringing 42 U.S.C. 1983, well, by way of what part of the Bill of Rights is that? If you're saying it's by way of due process, okay, cool. Now, how was due process violated? Well, due process was violated based on battery. Okay, what are the elements, test, and standard of battery? You have to know it. We all love medics and firefighters. That's subjective. But we shouldn't hesitate to wake them up and let them make the call on whether an arrestee is in medical distress. But this last phrase can also be read in a double-speak manner, where it says that the employee cannot sue their employer. So listen to it from that perspective. Local government may not, however, be sued under Section 1983 for injuries solely by its employees or agent. They cannot be sued by its employees or agent. And this is telling you that if we're hiring you, you can't sue us using this. See the dialectic principles? In other words, a municipality cannot be held liable under Section 1983 under Respondeat superior theory. We'll stop right there so the video does not get too long-winded. As always, when a video is long-winded, people's short attention span causes them to lose focus of the substance. In summary, 42 U.S.C. is not the way to go if you want to hold someone personally liable. But if you do somehow manage to use it, know that you still have to tether to specific elements, test, and standard of other tort claims in order to qualify this. And those specific tests, standard, and elements of other tort claims have to be tethered to something called the Bill of Rights, as shown in other videos relating to 42 U.S.C. claims. Once that is done, your claim should be really focused on that Constitution and the customs. When you want to say, well, their policy said this, policy said that, you cannot make stipulation of what their policy says, whether it's right or wrong, unless you're an employee or unless you are part of the interest holders of that entity, because their regulation is for them, not you. Regulations and policies are for internal control, not applicable to you. And instead of saying, oh, they were not trained properly, no, say they were in fact trained properly. And part of the proper training is a custom which was performed to your detriment, which gave rise to your cause of action. Therefore, that employee got that custom from someone's direction. Until next time, take care. Best of luck. Hey, beautiful people. I'm inviting you to come join my Patreon page. We speak about everything we don't speak of here on YouTube on the Patreon page. We speak of establishing privacy in many different means, how to hold tortfeasors liable, the different types of discharge, and the steps to actually do it. Now I'll be showing my own proof of the success, the intricacies involved in why and how it works, and the things no one else would tell you because they've never discharged themselves. The intricacies of settlements, suing people, and many other basic things like other tools that you can use privately, things of spiritual nature, because this goes beyond what you observe with your five senses. And if you just want to limit your remedy to just what you observe with your five senses, think again, because the other side is not playing in that realm. It's not an even playing field. Other things like study tools are shown things regarding trust and asset protection, and how to lay your trust properly the way people seek it, and the advantage of how to do it. Banking, the functionality of how they function, and the validity of it that a lot of people misuse or are misled by, where they think, oh, these other guys are bad, so now I have to just go into argument mode. No, you don't always have to argue. The law is perfected for your benefit if you're competent about it. Many things regarding child support, different examples of settlement checks, and the videos on it, the different aspect of how you can broaden your mind internationally beyond the little chicken scraps that people are picking up when it comes to passport and things of that nature, how banking work, how property protection work, the details of copyright, tort, privacy, different types of trust, the intricacies, and exactly why and how they are done, the intricacies that people from other parts of the world know about trust that you don't. Just because you read something on social media and whatnot doesn't mean you really got it. The intricacies of how to use certain jurisdiction and the stuff everyone speaks of. More in child support, more in trust, more in court, more in spiritual nature of things, etc., etc. The fact that tax avoidance is different from tax evasion. The importance of things in commerce and how to actually function in commerce. How to actually really do things as a natural person is beyond speculation. But let me give you this caveat. If you're looking for a cookie cutter or some quick fast food way, this is not it for you, either here on YouTube or on Patreon. But if you're serious about your education and the function and application of it, rather than the mere accumulation of information, then come on over on Patreon. There are things we speak about over there that are universally and exponentially beneficial compared to that of the ones we speak of on YouTube. And more importantly, the practicality and the actual use of it. Take care. Best of luck.